For those of you that don't know us, Actons, or me, I'm Nick Elliott, and I head our Employment and Dispute Resolution Group. I'm going to be presenting with some of the team today, who I'll introduce in a second. We are based out of Nottingham. We are a firm that covers a fair range of commercial work as well as employment law. We also have a dispute resolution team that deal with commercial disputes, a corporate and commercial team that do sort of M&A business transaction and commercial terms and conditions, and we have a real estate team, property acquisition, sales, leases, that kind of thing. We work with a range of clients, a number of really excellent East Midlands based SMEs, but also a number of household names that you'll recognise, some of which are on the slide, across the country. So a lot of you are on the call already, and it's great to see those names, even though we can't see your faces. In terms of the team presenting today, we've got James, who heads our employment team, and Laura, who's an associate in the team. And as before, we try and mix it up so you're not listening to one of us for too long, and hearing a different voice and a different presentation style. But yep, that's the team, looking good. So in terms of the plan for today, we're going to be covering quite a wide range of things. We expect it to be about an hour or so in terms of the session. It's perhaps a little less interactive than the sessions that we've run before. So bear with us because we will be talking to you about things that are coming up in the main. So the government's been pretty busy introducing new legislation in the main, which is what we're going to be talking about, though lots of it hasn't yet come into force. So you'll have seen, no doubt, various updates from us and others on some of that stuff. But to a certain extent, we're sort of crystal ball gazing. Some of that is in train, as it were, already, and will likely become law at some point, probably sometime next year. Other bits of it don't have a date for implementation yet. And other things that we're going to talk about, particularly in James's sort of other update session, are possible changes that might, for example, happen if there's a change of government at some point in the future. And obviously the main parties are setting out their stall on some of that stuff. And James is going to talk us through some interesting things there. And then just to finish up, we're also going to look at some case law, so some cases in the Employment Tribunal that have delivered judgments in the last year or so, and we're going to hopefully draw out some interesting points from those for you. As we go, you'll see there's a chat function. We're really happy to make it as interactive as we can as we go, and obviously there's three of us presenting, so the other two will be manning the chat as we go. So if you are happy posting questions in there, we're really happy to take those as we go. It's trickier obviously on Teams for us to do that talking to each other, but if you do have sort of questions or queries as we go, please feel free to pop them in the chat rather than the Q&A. We're going to use the chat just so that we can keep an eye on that all together with all the other links that we might be sharing. And then we'll have a bit of a Q&A at the end, where if you're feeling brave and you'd like to ask us a question and unmute, we'd be really happy to take questions there as well. So hopefully all that makes sense. If it doesn't, pop a question in the chat, and we'll field that as we go. So my section to start with is covering workers' rights in 2024-2025, and some of this might actually go as far into 21-25, which seems like a long way away, but of course we're not actually that far off 2024. And if, like me, you're thinking, where on earth did 2023 go? Actually, some of this legislation will be in force fairly soon when it comes next year. So we're going to look at a range of things, and that slide is a kind of summary of the bits that I'm going to talk about. It looks very wordy. It doesn't make a huge amount of sense, and we're going to unpack it in a bit more detail. What I'd encourage you to do on that particular slide is look at the words in brackets, which essentially give you a hint as to what the legislation is about. One is a bit more vague, but we'll look at that, and that's the Equality Act amendment. but the others, there is a bit more of an idea as to what they actually involve. And then what we've included there is the expectation in terms of when this will actually come into force. And a number of them have received what we call royal assent, which is effectively, yes, this will become law. But the date on which that actually happens sometimes varies, and sometimes it's not even possible to know exactly when the implementation time will be. But that's sort of our best guess, or our best knowledge as to when those things will be happening. So let's have a look at those in a bit more detail. So the Employment Relations Flexible Working Act 2023. So this is an amendment that's coming likely by August next year, which will change the statutory process for employees making flexible working requests and employers responding to them. And again, the slide quite helpfully, I think, summarizes the change, or the main changes. And the fundamental one there is that an employee can bring 2 requests within any 12-month period. And these kind of flexible working requests are things that you'll probably be familiar with. Things like, can I change my working hours? Can I change the place that I work? That kind of thing. Previously, and under the current law, it's only 1 request in every 12-month period. And actually that will increase the ability for employees to make those requests. Employers need to respond to those within 2 months of the request. That's a shortening of the time period. And there's a new sort of requirement for employers to consult with employees if they're refusing or denying the request. And that kind of minimum required consultation period is as yet undefined. So we're still waiting for some detail on this. Now, it would be interesting, again, utilizing the chat function, if people were prepared to share whether they've seen an increase in flexible working requests. Obviously, post-COVID, there's been a fair shift in terms of flexibility of working, with hybrid working from home, more of the time, working from various other locations, not even necessarily home. And I guess my view is that some of that is now kind of baked in to a certain extent for employers. And I do wonder whether actually we may be seeing fewer flexible working requests anyway, because people are just given more flexibility. But I think the last time I suggested that, the feedback from our guests was that actually they were seeing an increase in formal requests. But again, it would be interesting if people are prepared to share whether they've seen an increase or not. That would be useful. In terms of just a couple of other points on this section, the legislation provides for employers not being obligated, so not having to provide the right to appeal a decision to refuse a flexible working request, though it is suggested in the ACAS code which covers it. So my guess is that best practice is going to be to allow an appeal to that decision and consider what the employee is saying. What in terms of why they disagree with the decision to refuse it. So I think that would make sense. It's just another step that allows you to get to the bottom of whether it will actually work or not. And some of you will be familiar with the sort of 8 reasons for business reasons for refusing a flexible working request, and that rule will remain unchanged. So they will still apply. It's things like costs, inability to recruit people to cover, performance drops, that kind of thing. So that will be the same. And in the future, and again, there's been lots and lots of talk about this becoming a day one right. So the ability to make a flexible working request applying from the first day of someone's employment. That doesn't currently apply. There is the ability in the legislation that's coming for the government to use secondary legislation to introduce it as a day one right. So that might be something that's likely to follow. And in fact, there are a number of employers who have already adopted that as a day one right. I think Tesco were one of those that was kind of cited in the press as, we're really getting on board with flexible working and we're going to make it a day one right, even though we don't have to yet. So that appears to be the direction of travel. Quite how that will work will probably be the subject of another session. But yeah, that's the upcoming changes on flexible working. The other interesting one, again relating to flexibility, but perhaps from the other side, is that there's been for a while, I think, a perceived sort of one-sided flexibility when it comes to employers and their employees who don't have a predictable working pattern. So we're thinking sort of 0 hours contracts, that kind of thing. And there's legislation that's coming, which is this Workers' Predictable Terms and Conditions Act, which again is expected probably September next year, so September 24, which is the government's attempt to address this. Now, again, lots of this stuff, your professional opinion is an interesting one, but also your political leaning, no doubt, will colour whether you think this is actually addressing the issue or not. And we're deliberately trying to avoid getting into that too much. But some would say this is a fairly watered down version of what it could have been, but essentially what it's doing is it's creating a right for workers who don't have a predictable work pattern to request one. But it is only a right to request. It's not a right to have, as it were. So it is similar in that sense to a flexible working request, and it applies to those people that have that lack a predictable work pattern, and those on fixed-term contracts of 12 months or less, and it will also cover agency workers. In terms of how it works or how it's likely to work, and when it actually comes into force, similar to flexible working, employers need to respond within a month of the request. There can be a maximum of 2 requests in a 12-month period. And as I said, it's a right to request, not a right to definitely have a predictable working pattern. And it's likely that there'll be an ACAS code of practice, we all have one of those, to be introduced, which will detail how employers should approach those kinds of requests. So again, whether it's actually addressing much, I'll leave for you to decide. It's certainly something that employers will have to be able to deal with. And my guess is that there'll be a similar sort of list of reasons that they can be refused, that request can be refused on. And it certainly will be, something that you'll need to be aware of should you get such a request if you employ people on that kind of basis. One for the hospitality crew, allocation of tips, some changes to that. Again, a perception, I think, and probably more than a perception at times, that certain employers were maybe taking advantage of employees who were receiving tips. So this legislation expected, I think, to come in May next year, so potentially one of the first to kick in, is designed to help protect employees who are receiving tips where employers might not be dealing with those fairly. So the emphasis here is on fairness and I guess transparency. And you can see from the slide, there is likely to be another code of practice issued later this year that will cover what fair allocation means. It's likely to apply to tips over which employers have control or significant influence. So I guess they would be ones that are, centralized in some way, rather than slipped into the hand or the pocket of your waiter or waitress. And I think it's a sort of thing that actually the hospitality sector have dealt with, for years, and it may be that actually, it's being dealt with properly already. But I think things like the fact that an employer will need to keep a written policy outlining how they deal with tips, they'll need to keep written records of all tips and to whom they've been allocated, may well add some additional administration, at least, even if employers are dealing with it appropriately already. That there will be, we think, powers for the tribunal to enforce this too. So they may be able to enforce compliance and revise the allocation of tips, may even be able to award compensation for loss, financial loss. I think there's reference to a £5,000 cap. Obviously, you'd be doing well on your tips to hit that potentially, but it'll be interesting to see where that one goes. Next one is Worker Protection Amendment of Equality Act. So this is the one that's not quite as obvious from the title, even when we look at the brackets, but it is amendment to the Equality Act. This one received royal assent actually very recently. I think it was the 26th of October. And as far as we know, is likely to come into force in the next 12 months. So that makes it all certain for us. I think, again, this was, there's been lots of stuff around harassment in terms of changes in the law over the years, particularly relating to things like third-party harassment. So employers having an obligation to protect their employees from harassment by third parties, as in people outside of their organisation. It was expected that that might be reintroduced as part of this. It's not, and this is quite specific in the sense that it relates to preventing the sexual harassment of workers. So it's a new element there, and it's a new duty to take reasonable steps, as the slide suggests, to prevent the sexual harassment of workers in the course of their employment. It's in addition to the existing all reasonable steps defence, which relates to general harassment. If there's a claim in this area, if the employer has complied with the new duty, then they can avoid an uplift to compensation. And again, you can see that from the slide. The idea being that it will encourage employers to do better in this area. So clearly an important one. I think the usual principles apply in terms of how you might do that, and taking reasonable steps, might involve things like training and policies, so that I think is something that we already know, and I think it is important, and we've certainly seen an increase in requests, as I said at the beginning, from clients for training in that sort of area around diversity and discrimination. So that is likely to be necessary moving forward on this point too. And then finally in my section, Wheel of Pensions, automatic enrolment, extension of that. Again, I'm not going to go into masses of details, partly because Laura's no doubt itching to get onto her section, but also it's pensions, and finishing a section on pensions is about as dull as it's possible to get. Apologies to any pensions people out there. But essentially, there is legislation likely to arrive, although again in my notes it says no current timetable, which isn't particularly helpful, but that's the way things are working at the minute. But essentially it's to extend the sort of auto enrollment provisions, where it's lowering the age threshold, it's reducing the lower end of the qualifying earnings band, in order, I suspect, it's not too hard to guess, that it's designed to encourage more people to be saving in their pension, which I guess is a good thing. What it is likely to do is to sort of add some additional admin from an employer perspective in terms of the number of people that you are having to deal with when it comes to this area. So enough of me, and I will hand over to Laura.
Thanks, Nick. Morning, everyone. So, yes, I'm not sure that I can follow pensions really, but we'll give it a go. So I am going to take you through some of the changes to family-friendly leave, as you will see from the slide. Over the last few years, probably last 10 years or more, there's been noises from all sorts of parties on if they were in, what they would do around this. And there's been various lobby groups and charities seeking to get things like carers leave in for many years. So the fact that there is now a Carers Leave Act is seen as a good thing for most people. So the one thing that I will say, as Nick has said here, I will take you through what we're expecting to see. You will see as we go through that there are a number of things where I will say we're not actually sure what that bit's going to be yet. because it simply hasn't been defined. So whilst all of these have got their royal assent and they are going to come into force, as you can see, over the next couple of years, there is a long way to go before they're in a position that actually we can all sit here and tell you exactly what they are going to be. So the first one is Neonatal Care Leave and Pay Act. There is currently no law which covers neonatal care specifically. So this is a brand new idea, and the intention is that it puts some legal support in place really to support parents or primary caregivers where their little one needs medical or palliative care when they're very newborn. The definition is yet to be specified, so as I'm saying, please take our word for it that this is what we know at the moment, but we will give more detail once we can. But the definition of what is likely to fall under this act and what is likely to be deemed to be neonatal care is the very first bullet point on this slide. So medical or palliative care for a continuous period of at least 7 days, starting the day after care begins, that commences within 28 days following the date of birth. We are expecting a lot more detail to come in on that. So one of the key questions at the moment is whether that is per child or whether it's per birth. We would expect that it follows things like maternity, which is per child, but we'll have to see what that is. There's no indication really on whether there's going to be any update on the commences within 28 days following the day after birth point. That is something that is written in there at the moment, but has a great big caveat on it that essentially just says to be confirmed. So one of the things that the government are looking at and we expect will come in either through secondary legislation or through changes to this is that neonatal care leave may be taken at an extended period, and that could be up to 68 weeks. So it's just worth having in mind that whilst this at the moment is very much deemed to be something that is perhaps an alternative to maternity or paternity leave and triggering those, there still needs to be some thought on how that's actually going to work in practice and whether it's going to be something that starts and stops periods of leave or not. You'll see here that it's a day one right, and it's up to a maximum of 12 weeks leave at the moment. So the key point there is obviously that there's no qualifying service needed to take that leave, and that the maximum there is 12 weeks, and it really does depend on how long somebody is in hospital and needs that type of care for. It is a separate period of leave to the other forms of family friendly, so it is, and the intention behind it is to provide an extra level of support during a difficult time. But as I've just said, the actual interplay between the other types of family friendly leave is not yet clear, and actually there's quite a lot of noise on making that clear and trying to work out how that will actually work in practice. So the pay that goes with this, the statutory neonatal care pay, you do need 26 weeks continuous service for that. So that mirrors things like maternity leave, where it's a day one right, but you still need to have a continuous service to get the pay for that. Protection from redundancy, the Pregnancy and Family Leave Act. So you'll see here that this act empowers government to pass new rules, the details of which are yet to be determined. Might be a running theme here. That's essentially this document, if you have a look, is a couple of pages long, which doesn't really say a lot other than the fact that they are going to bring in some enhanced redundancies provisions. So this is one that I strongly expect that we'll be having more discussions on and perhaps doing more blogs, articles, or even raising it again in webinars in the future. But the intention behind this is to give those who are pregnant or a recent returner from parental leave priority status for redeployment opportunities in a redundancy situation. So you might be aware that the current law already provides protection to employees on maternity leave only, but the thinking behind this act is that it extends it and goes further, and is the intention to extend the protected period of pregnancy to include 6 months following an employee's return to work. You might ask me exactly what a protected period of pregnancy is, and you may be not surprised to know that we don't know yet. So at the moment, we are expecting it to be triggered at the point that an employee tells the employer that they're pregnant, and then finish and cease on 6 months after their return to work. You'll see that it is likely to apply to those on maternity, adoption and shared parental leave. Which may leave you questions with, well, how does that work then? If the period of protected pregnancy starts on the day that they tell you that they're pregnant and finishes 6 months after their return to work, how can that fit with some of these types of leave? And the honest answer is we still need to wait for that to be determined. So things that are being looked at the moment and we expect to see changed in secondary legislation, and there's an awful lot in this one, unfortunately, that does need quite a lot of nailing down and rules setting out. Our discussions on whether the 6 months extension will apply to everybody, or whether it will actually only just apply to people returning from maternity leave, because that already has some enhanced protections. So whilst they're saying that they're going to extend it and it's likely to apply to all of those, there is quite a lot of noise that suggests that it might not in reality once it comes through. And the thinking behind that is that the Act is intended to support back to work people who have been off for a prolonged period of time. And therefore, if somebody has taken 1 or 2 weeks of shared parental leave, is that really the most appropriate way of using this new Act? And that's where the ideas and discussions around that are coming from. And then we've got the Carers Leave Act. So in headline terms, this provides a minimum of 1 week's unpaid leave for employees who care for dependents with long-term needs. You'll see that in this case, we do actually have some definitions, which is good. So the definition of dependents matches the definition in the law surrounding the right of time for dependents. So it's spouse, civil partner, child, parent, or person who lives in the same household as the employee, other than by nature of being a lodger or a tenant or anything like that. Or, and it's a catch-all provision, this one, someone who reasonably relies on the employee to provide or arrange for their care. There's also then the long-term need. There are some ideas set out on what that is likely to look for on the slide. So mental or physical illness or injury that's likely to require care for more than 3 months, a disability under the Equality Act 2010, or care needs connected with old age. There is still some work to tighten those up, and we are expecting, as the slide says, some secondary legislation that is going to put in place what is likely to be a particular activity that is appropriate for care leave, what isn't to be treated as providing care, and that will only help try and narrow that one down. The thinking behind making that as watertight as possible in terms of what actually is a long-term care need is so that this isn't a new act to replace things for short-term care, by which the rights to time off dependents or annual leave or anything else like that still the most applicable way to take that. The one thing that I'll flag is that at present there is no requirement for employees to provide evidence of entitlement to this, which fits with quite a lot of the other family-friendly leave policies. There is a move to say that actually they think there might be a requirement to do that, which may give rise to some concerns from employers from a handling of third-party medical data. So if you've got a dependent's medical record, that is something that they're alive to at the moment and may therefore be debated on and changed in the future. But that's just one thing to look out for. I will pass over to James.
Thanks, Laura. Good morning, everyone. My section is a bit of a mixture of different things, so we'll jump around topics. It's been given a very well thought through subject heading of other. I'm going to start with Labour Party conference pledges, very, very briefly look at the national minimum wage, and then just cover briefly a recent legislative change that's unlike some of them from earlier today, has been passed and is clear and easy to follow. The Police, Crime, Sentencing and Courts Act 2022. So, Labour Party conference pledges. This is where I do a big disclaimer and say this is not a political webinar, and I'm not making any political comments regarding the Labour Party or indeed the current government, who, for the sake of balance, although it's not the BBC, the previous bits were all laws passed by the Coven government. So I'm not sure what that sound is in the background there. Anyway, so not a political webinar, but the reason we're reporting the Labour Party proposals is really twofold. One is the opinion polls suggest that it may be more likely that we have a Labour government come the next election, at least as they currently stand. And secondly, because it's interesting that they hint at a lot of potential change to employment laws that would shake up the world that we all inhabit. So it's worth at least having a nosy as to what might be coming down the line. And for those of you who wonder where I've got this from, it's in the main a combination of the policy paper called A New Deal for Working People that Labour published quite a while back, and then also looking at what they've said at the recent Labour Party conference on workers' rights. So as with some of the other things we've talked about, but even more so with this, it could mould and morph before the election, after the election, before any of this could plausibly be law. But nonetheless, I think some of it is quite interesting. So on to the substance. And I should say that they have promised, if they are in power, Labour, to release an employment bill within 100 days, which for some of this stuff looks achievable, and some of it would be a really, really good effort to get some complicated law through so quickly. But I guess that gives them a bit of scope. They can no doubt do more than one employment bill if they wanted to, and one more than 100 days afterwards. So what are we going to talk about? I've picked out some of the more interesting pledges and parts of the Labour proposals. The first, the genuine living wage. As the slide says, the headline is that the idea would be that the minimum wage, and as you probably know, the top rate of the minimum wage is sort of colloquially known as the living wage. The idea being that the living wage in law actually coincides with what people might more on a layman's level determine as the living wage. And one of the ways that they're pledging to do this is to increase the remit of the Low Pay Commission, who make recommendations. So in broad terms, I think this is code for they would push up the living wage based on recommendations of the Low Pay Commission. Other rights they'd look to extend that would be relatively straightforward to do, I suspect, from a legislating perspective. That would be increasing the rate of SSP and expanding it to self-employed people and removing the lower earnings limit. So the limit by which you qualify, that you'd think be relatively easy to do. The next pledge that Labour have announced is again slightly tangential, but an interesting one nonetheless. Stronger enforcement of workers' rights by implementing a single enforcement body. Now, there's been talk of a single enforcement body by the current government or even previous governments to this, and it to me never seems to go anywhere. I think that's because it would be quite difficult and involve quite a lot of changes just to infrastructures and government bodies. For those of you that are familiar, currently things like disputes over SMP are handled by HM Revenue and Customs, and they have certain enforcement rights in regards to national minimum wage. And as you're probably all more familiar with, other employment rights, such as deducting wages, is within the jurisdiction of the employment tribunals. And it's not entirely clear to me from what I've read how the Employment Tribunal Service would dovetail with the new single enforcement body. Would it be part of it? Would it be it? Would it be something else? In fact, the single enforcement idea was something that was said way back in the Good Work Plan that Matthew Taylor prepared a while back. So it's a long-running idea, but I suspect that it's a good idea, but might be harder to actually flesh out with detail and implement. The idea when they talk about stronger enforcement is along the lines of there being inspectors who would have the power to initiate civil proceedings or even prosecutions around areas such as the national minimum wage, health and safety law, worker exploitation, and even it was mooted the sphere of discrimination. Now, I did wonder as an employment lawyer who deals with those matters in the tribunal how an inspector could sort of nip into a workforce and wheedle out discrimination, but I guess it's thinking about the most extreme cases rather than the sort of more nuanced matters we might deal with in the employment tribunals. Actually, before we move on to the ones on this slide, there's a few other interesting powers that Labour had mooted. The first was the single worker status. So you're probably all familiar with the concept of employees and workers. Employees, everyone's like to be familiar with, but for those who, just a quick reminder on what a worker is someone engaged via a contract of employment or some other contract to provide work or services personally, but one that is not a client or customer relationship in respect of a business or being operated by the individual. So sometimes there can be a bit of a grey area in terms of workers and self-employment, where it's suggested that the individual who's engaging to provide their services is running their own business. And that's often an area of dispute whether that's really the case or not. That's something that they would probably look to attack separately to try and avoid any kind of perceived abuse of self-employment. But the single worker status would just be moulding employees and workers into one, presumably the idea being that the workers would get the rights that the employees get that they don't currently get. So things that workers currently get would be things like the right to the minimum wage, but things that they don't, and holiday pay, but things that they don't get would be things like the right to be not to be unfairly dismissed, and the right to a whole load of the family-friendly leave that Laura mentioned earlier, or existing ones that are already in force. So it would be simpler if there was one status, but that would increase the rights for a number of people who are workers but not employees. And then the kind of linked but not quite the same proposal is this so mooted idea that everyone has day one rights. Nick mentioned it in the context of flexible working, but perhaps the most significant and frankly would be easy to enforce would be in respect of unfair dismissal. Currently there's the 2-year qualifying period. You could just change the little bit of the legislation that says 2 years and say there isn't a period, and all of a sudden employees, and if you melded a single work status workers, would have significantly additional rights. The most obvious context that I was thinking was just the classic probationary period, and employers would have to be a lot more tight in their processes to ensure that they had a fair reason for ending employment during the probationary period and that they acted fairly in doing so. It would be interesting how the case law on that would develop in terms of the tests for reasonableness, because it'd be interesting to the extent to which employment tribunals would be cognizant of the fact that the employer might want to, or might reasonably decide to let someone go in the first 3 months on thinner grounds than they might inside 2 years based on the premise of probationary periods. But that would be an interesting development that we'd all grapple with if that did come in. So the only thing with that springs to mind, again, this isn't a political comment, but given the current state of the Employment Tribunal service, if you've got claims rumbling through the system, you'll know that it in the main isn't very speedy. If you change the qualifying period of unfair dismissal from 2 years to nothing, or even a year probably, I suspect you'd see a surge in cases, and unless the change in the law was sort of coupled with a plan of action to resource the Employment Tribunal appropriately, it could lead to just a big meltdown and backlog of claims. There's already a comment on banning fire and rehire, and I haven't even got to it yet, Andrew. But banning fire and rehire, it's a favourite topic of mine, just because it slightly irritated me when the P&O situation was in the press, that everyone got very upset about fire and rehire, and in that case there was no rehire. They just fired most of the people at P&O and then hired other people, which isn't what is now referred to as fire and rehire. So you could reasonably object to that and have a different view on fire and rehire because they're two different things. So fire and rehire, just a reminder, is the sort of new trendy phrase for a thing that existed long before, where employers would terminate employees and then offer them new terms of employment, usually in a situation where they wanted to change something but the employees couldn't agree, whether that was a place of work, whether that was their pay, whether that was other terms and conditions. And what came off the back of the P&O case, other than sort of political unrest and general public disapproval of the practice, was a new ACAS code on the issue of fire and rehire, and that went through consultation and was revised, and then they actually did publish a finalized version of the code. But what they didn't do, the current government, is actually enforce it in any way. So currently there is a finalized code, which I've read and you can read, but isn't one that employment tribunals would look at yet, because it hasn't been sort of officially brought into the law in any way. What does it say, the current code? As I say, the one that has no particular effect. Well, not a great deal that you wouldn't expect it to if you knew the case law on fire and rehire. In some ways, I thought the code was very sensible, because if an employer or an employee had the code and then analysed what had happened, they'd be able to quite accurately predict the outcome of any claim for unfair dismissal, because it was all based on the current law. So talks about things that employers should do when seeking to agree terms and conditions and are considering so-called fire and rehire, which would be consulting, meaningfully engaging, feeding back on comments, trying to reach agreement, allowing sufficient time, that sort of thing. And it set out a bit more of a framework than exists from the case law. So in that sense, it wouldn't have been particularly groundbreaking. So I assume the Labour proposal is to do something more than that on the basis they don't like the premise of dismissal and re-engagement rather than the kind of more savage P&O practice. But there's no real detail on how they do that. And the problem with it is, as a proposal from a lawyer's perspective, is that they'd have to change the current Employment Rights Act interpretation of unfair dismissal in a way that will probably be quite logistically tricky to do. So I suspect that the likely thing is that will be slightly shelved, and that either the current statutory code will be published by either the current government or a Labour government, and it will be a sort of minor tweaking on that rather than an actual ban of fire and rehire, because that would take a lot more doing. The next one, completely different topic, inequality and pay gaps. Most of you are probably familiar with gender pay reporting, which my notes remind me that you have to do if you have 250 plus employees. That is proposed to be extended to include ethnicity pay reporting. So essentially, you do the same thing, but you report the gap in between different groups as opposed to genders. It's slightly unclear how there would be disability pay reporting. I only say that because if you've only got 250 workers and you had 1 or 2 disabled workers, then as a sort of statistic analysis, it'd be fairly meaningless. Whereas with gender and ethnicity, everybody has that. So at least the idea of 250 is then you've got a sample that's worth analysing. If you've got 1 person out of 250, it could be the chief exec, or it could be the person right at the bottom of the pyramid. I mean, it's not really telling you anything. So I don't know whether the disability will have to be nuanced to have a larger pot before it applies to anyone, but we'll see. And then the single source test is something totally different. That's to do with equal pay legislation. Now, this actually, although it's in the Labour Green Paper and Policy Paper, is something that the current government has already said they're going to do and will do. So this is another thing that will happen. But all that the single source test is doing is essentially becoming part of the law to ensure that it doesn't not become part of the law. Slightly, what do I mean by that? Well, those of you that attended the EU law bonfire seminar will know that legislation was passed that kills off automatically a whole load of EU derived regulations, unless, well, it does kill them off, and then it gives the government the power to re-implement the things they want to keep. And there's been some tweaks to that, with certain things being delayed so that things don't just disappear while we've got time to re-implement them. So the single source test is one of those things that's being re-implemented in UK law to replace the equivalent provision that exists until such time as it disappears on the EU bonfire law. So that's no change at all, really. And I won't go into the technicality of it because it's a complex piece of equal pay legislation, but rights are remaining the same, essentially. They're not becoming weaker, as was feared. And as Labour were proposing to fix, but they won't now need to, whether or not they're in power. And finally, trade unions, always a polarizing topic, trade unions for certain employers. The proposals on this are quite extensive and would be a big departure from current arrangements. So there's proposed to be fair pay agreements, which would in effect be a form of collective agreement applying across sectors. So it's been described as sectoral collective bargaining. And the actual bargaining will be done by workers and employer representatives. So not just individual employers, representatives from employers would be representing that sector as a whole. And the idea would be they would have a sectoral collective agreement that would cover terms and conditions that would be binding on all workers in the sector, covering key matters such as pay, working time, holiday, training, health and safety, diversity and inclusion. And the idea being that it was a sort of a floor, a minimum, so that standards in that sector couldn't slip below the floor. I was trying to ensure that this was balanced, because that'd be you could say that's a very Labour Party proposal in terms of their keenness to empower unionised workforces. But the contrast I had that I thought was quite interesting was if you're in the education sector, you might remember the advent of academy schools, which meant that academies could move away from the nationally agreed teaching unions terms and conditions. And that was implemented by the Labour government of Tony Blair. So this would presumably, if the school sector or the education sector was part of the sectoral collective bargaining, undo that entirely. So it's interesting sort of how things have changed over the last 20 years if we did get to that point. And then the second aspect of the trade union reforms that they're touting is to widen the scope of trade unions away from the more traditional areas they're currently in, public sector and certain aspects of the private sector, into more of a mainstream application. And one of the ways they've suggested that might be done is by simplifying the statutory recognition procedure for trade unions. So there already is a statutory recognition procedure whereby unions can seek to be recognised by employers. I won't go into the detail of it, other than to say that the suggestion that it could be simplified is definitely true. It is complicated. But one of the things that's interesting is that people might be surprised in the sort of general public, if they didn't know how this worked, what the threshold for union recognition under the statutory procedure is. So currently, you only need to have a proportion of at least 10% of union members in the proposed bargaining unit, and a bargaining unit that's likely as a majority to support union recognition. So you don't need 60% of the proposed bargaining unit to be union members. So I've got many clients who say to me, we don't really have much union recognition, but we have a union. And so it's interesting that despite that the perception is that the unions should go further. So I could see that the arguments on both sides there, but it's interesting that at the moment the bar is quite low in theory, in terms of the need to have many staff who are actually union members before the unions could apply for recognition. So it'd be interesting to see if that did come in, whether or not there would be a big change to a more unionised workforce nationally. And as the policy paper points to, it is comparatively high in other European countries in terms of the extent of unions in workforces. That's it for the Labour proposals. Now a very brief couple of slides on the national minimum wage and the changes to the Rehabilitation of Offenders Act. So the national minimum wage, as is always the case seemingly, is going up. There's a slight tweak to the national living wage, which, as I said, is just an age-related rate of the national minimum wage for the purposes of the legislation. And it would change to those aged 21 plus, not 23 plus, and is going up by a fair chunk, as the second bullet point says. And the Low Pay Commission's recommendations are yet to be announced. But as I said earlier, and as it's been hinted at by Labour, what the Low Pay Commission recommends is just advisory, and whether the government does anything with that is entirely up to them as it currently stands. And this is the act that the name of which I always forget, but luckily is on the slide, the Police, Crime, Sentencing and Courts Act 2022. And those of you that are familiar with recruitment and the Rehabilitation from Offenders Act will know that in certain circumstances, certain offences need to be declared, and then after a certain amount of time they become spent and don't need to be declared. And what this act does is it changes the periods of time for offences to become spent and therefore required to be declared, as it says on the slide. I won't read it out, but it's worth noting. As always, there are certain exceptions, usually due to safeguarding for different types of work type. And the next slide I'll leave on the screen for a few seconds so you can read it, because that sets out nicely in a kind of tabular form what the change is, so you can compare and contrast how things are changing. But as you can see, it's quite significant in that the length of time goes down quite a lot. The other reason to give you a few seconds on that slide is because the next case is on holiday pay, and that gives everyone time to prepare for the possible confusion that I will get to. So we're doing 4 cases. I'm going to talk about the first one, Agnew, and then Laura and Nick will finish off with the other 3 perhaps more interesting cases. So this case is a Supreme Court case that you probably read about relatively recently, the Chief Constable of Northern Ireland, Agnew. But as it's holiday pay, there's no point starting with the current case. We need to go back and remind ourselves of the saga of the last 10 years. And this particular saga is best started by the famous Bear Scotland case in the Employment Appeal Tribunal in 2014, which could be described as a moment when everyone panicked. And the panic was that people realised, based on the EAT's judgment, that perhaps we'd been paying holiday pay wrongly for a long time. And by wrongly, I mean the Bear Scotland case said in certain situations, overtime needed to be included in the method of calculating normal remuneration when making holiday pay. So holiday pay needs to be normal remuneration, and Bear Scotland said in certain types of overtime in certain scenarios would need to be included. The subsequent cases that followed in the years to come defined what precisely needed to be included, and it expanded to voluntary overtime if it was worked sufficiently regularly to form part of normal pay in another case. And in the famous Lock and British Gas case, it was covered that, it was held that commission needed to be included as well if it was regularly received as an ordinary course of working, as it was in that case. But the reason that I go back to the Bear Scotland case is because a couple of things arose from the Bear Scotland case that have been uncertain for the last 9 years. The first one related to how far back you could claim. The fear when Bear Scotland came up was that you could claim underpaid holiday as an unlawful deduction of wages. An unlawful deduction of wages claims, and that's settled. Nobody's ever disagreed with that. But an unlawful deduction of wages claim, whether it relates to just normal wages or holiday pay, can be made within 3 months of the date of the deduction. But you cannot just claim for the deduction that happened 3 months prior or up to 3 months prior. You can also claim back for as long as you like, as long as there is a series of deductions. And what the Bear Scotland case did was brought in an interesting idea that might impact what might be a series of deductions. And it was suggested in the judgment that perhaps if there was a gap between the underpayments of 3 months or more, it would sort of quote unquote break the chain of deductions. So a correct payment might break the chain, or just a gap between payments if that meant that the underpayments were more than 3 months apart. So people were very interested in trying to argue how we might avoid going back to 1998. Part of the fear that came out of this judgment in 2014 about breaking the chain was mitigated somewhat, because shortly after the 2014 decision, the government of the time implemented the slightly drably titled Deduction from Wages Limitation Regulations 2014. And what that said was you could only claim back 2 years regardless of the chain. So if there was a chain, the chain stopped at 2 years from the date you put the claim in. So rather than going back to 1998, you could only go back 2 years from when you presented your claim. But the reason this case is so interesting, Chief Constable of Northern Ireland, is that regulation, although it applied in England and Wales, does not apply or didn't apply in Northern Ireland. So this case, Agnew and the other claimants were claiming back in some cases back to 1998 if they'd been employed that long. So what was the outcome? Well, perhaps unsurprisingly, they decided that a series of deductions does not necessarily end if 2 consecutive underpayments are separated by more than 3 months. And whether 2 or more deductions constitutes a series is a question of fact. That was consistent with the other case law unrelated to holiday pay on the issue of chains of deductions. And in Agnew, the Supreme Court held that because the deductions were factually linked by a common fault, the common fault being calculating the holiday pay wrong, they form part of a series, even though there might have been intervening payments that weren't underpayments. And one of the reasons why there might have been intervening payments that weren't underpayments is because of the slightly strange way of how UK holiday is calculated. So under the statutory scheme, workers are entitled to 5.6 weeks holiday per annum, but 4 weeks of that derives from Regulation 13 of the Working Time Regulations and 1.6 weeks of it under Regulation 13A. But the requirement to include overtime in the situations where you need to include overtime when calculating holiday pay only applies to the Regulation 13 leave. So there was this argument to say that if they've been paid 5.6 weeks, but we underpaid 4 weeks and 1.6 weeks was correct, then the correct payments for the 1.6 weeks would break the chain. This case said that was wrong for 2 reasons. One, correct payments doesn't necessarily break a chain of underpayments. And 2, I think very sensibly, they said that this distinction between the 2 types of leave is totally artificial. And I did enjoy this comment because I think other than about 3 or 4 employment lawyers, nobody would ever think, oh, I'm on holiday, but am I on Regulation 13 holiday or Regulation 13A holiday? They correctly concluded that no employer or employee, other than perhaps slightly weird ones, had ever thought they were on one type of leave or the other, and that it was just totally artificial to say that, oh, no, actually, it was a 13A holiday, so you were paid correctly, so it breaks the chain. So Agnew, to a certain extent, makes it a bit simpler in that you should just assume if you've been paying it wrong and there's a chain of wrong payments that you go back for 2 years because that's the backstop, or if you can't rely on the backstop because that doesn't apply, then you could plausibly go back to 1998. But what Agnew doesn't change, it's worth reiterating, is how you actually calculate holiday, which is as covered by previous seminars. I won't go into that now because we'd need another hour. So that's that for Agnew, and now on to some totally different cases with Nick.
Thanks, James. I should also say James is helping a number of clients with almost an audit as to whether they're paying holiday pay correctly. And as you will have picked up from that case, it's a very complicated area, and James is very excellent at getting to the detail and understanding it and helping clients work out whether they've got a problem or not. So if you are in any way unsure as to whether you're getting that right, which would be completely understandable because it is very, very complicated, then do get in touch, preferably with James. So on to the next case, which involves ACAS, which is quite fun. Not in the normal sense, as in a claim going to them ahead of it hitting the Employment Tribunal, but actually a claim against them by a Mr. Corby. Now, interestingly, Mr. Corby was one of their ACAS conciliators. And again, anyone who's been involved in an Employment Tribunal claim will be familiar with that service that the conciliators provide, trying to broker a resolution or a settlement to a potential claim, or in fact a claim that has been brought. But Mr. Corby decided that he needed to bring a claim against ACAS, and we don't have a huge amount of detail as to what he alleged was actually being done to him by either ACAS or his colleagues in terms of discrimination. But one of the claims that he brought was a claim for discrimination as a result of his philosophical belief. Now, that philosophical belief was his opposition to critical race theory, which some people may be familiar with, some people may not be. But essentially, he believed that the cause of racial equality was best advanced by valuing people based on their character rather than their race. So that's the general principle there. As I say, not much information available other than that, because this was just a preliminary hearing on whether the issue or the religious or philosophical belief that he held was protected under the Equality Act. And again, this is, I think, increasingly common in terms of the number of cases that we're seeing in this area. possibly because of society becoming increasingly polarized, people holding views very, very strongly and expressing them, and that sort of leaking into the workplace. So I think it's a useful one for us just to focus on. We do sometimes have clients express surprise at the fact that a certain belief that somebody holds might be protected as discrimination, and therefore sometimes it's missed, I think, as a potential discrimination issue. And sometimes, you know, the feedback is, oh, well, it sounds like they've just made that up, and now you're saying that it might be protected under the Equality Act. Well, there's a test for that was set out in a case called Granger, often referred to as the Granger test, and that's essentially where the tribunal weigh up whether someone's belief is sort of worthy of protection almost under the Equality Act from a discrimination point of view. And this slide is helpful in terms of summarizing that Granger test. And then you'll see also there's some detail as to what the tribunal found in the Corby case. So first stage of the test is that it must be genuinely held, and they found that Mr. Corby did hold the belief genuinely. It needs to be more than a mere opinion or viewpoint. And what they found was that he had carefully considered this belief. It was based on his research and writing and the way that he lived his life, and therefore that element of the test was made out. It needs to concern a weighty or substantial aspect of human life, and you know, the critical race theory and his views around that were clearly more than just trivial issues which affected society. So again, that was made out when it came to that part of the test. It also then needs to have what the case describes as cogency, seriousness, cohesion, and importance. And Mr. Corby was able to show in his witness evidence at this preliminary hearing that his belief was logical, structured, it influenced how he lived his life, it was capable of being understood, and it related to important matters of human behaviour. So again, another tick in the box for that test. And finally, it needed to be worthy of respect in a democratic society. So that's the final part of that test. And sometimes that's where a belief that someone holds will fall down, where it is effectively fundamentally against the fundamental rights of others, other humans, essentially. But actually, in this case, they found that his belief related to the best way of eliminating racism, and therefore, despite being objected to by some of his colleagues, was again another tick in the box for the final element of that test. So as far as we're aware, on the preliminary hearing, he made that out. Now, where that will go, I understand that Mr. Corby, as far as we know, is still employed by ACAS. And it may be that the rest of the case is proceeding, or in fact there's a settlement of some kind, which would be obviously something that ACAS are good at. And it may be that we don't actually find out any more detail, but it's quite an interesting reminder of the Granger test. It's an interesting one because it involves ACAS. I think in terms of wider sort of applicability for employers, I think it's also a useful reminder that beliefs that your employees hold may well be philosophical beliefs and therefore protected under the Equality Act. Even sometimes if you as the employer or colleagues of that employee find them offensive in some way. And I think there's this difficult balance now for employers to grapple with in terms of there having been a number of cases similar to this where people have said, well, this is my belief. This is what I hold true, and other people might not like that. And as an employer, from a PR perspective, you might not like that. But I think it's being careful when we're, for example, disciplining employees for holding those views. If their colleagues object to them, for example, and getting to grips with where to draw the line on that, which is not easy. And I think certainly if there are problems around infringing the rights of others as a result of the beliefs that are being held and how they manifest in the workplace and how people are behaving. So, for example, I'm clearly not saying that harassment of other colleagues is okay, but it is a difficult it is a difficult area, I think, increasingly for employers, which is why actually applying some thought to it from the employer's perspective, and I guess also going back to something I mentioned earlier, training your people on how to navigate some of these issues well, it is really important too. So that's Corby. I think Laura's picking up the next one.
I am, thank you. So, I'm trying to scroll through and it is absolutely not working for me, which is always helpful.
I'll do the slides for you, Laura, don't worry.
Thanks. Very supportive team. So I am going to talk to you about a duty to make reasonable adjustments. If we can get the slides up on the screen. I don't know if you guys can see them. We've got AECOM Limited versus Malon, and it's an employment appeal tribunal case. So the background to this, I'll just run you through what happened there. There was a claimant, Mr. Malon, who applied for a job with AECOM, which required him to complete a standardised online job application. He said that he had difficulties with that, emailed AECOM and said, I have dyspraxia. I'm struggling with the standardised online job application process. Could you please arrange for a telephone call? So he asked for them to obviously do that by telephone. The respondent, so AECOM, responded via email saying that the online process, essentially they could help him via email on the online process, but they couldn't provide or wouldn't provide a telephone alternative. Mr. Malon then didn't respond to that email, so just left it in his inbox presumably, and was therefore unsuccessful in his application because he hadn't managed to complete that online application form. So taking it back a little bit, the legal position on the duty to make reasonable adjustments is where, and you'll see on the screen, a PCP, so provision, criteria, or practice, which is a rule or something that applies. Here, the requirement that all job applicants must fill in the online job application form. Puts a disabled person at a substantial disadvantage, which is a more than minor or trivial disadvantage compared to those who are not disabled, and that is what triggers a duty on an employer to make reasonable adjustments. The duty applies only where the employer has actual or constructive knowledge of disability. So actual knowledge is the employer knows or is aware of the disability, and constructive knowledge is where an employer should be aware of the disability, i.e. there are signs in place that it could show that, such as prolonged sickness absence, etc. So the EAT found that a blanket approach put those with dyspraxia at a substantial disadvantage compared to those without the disability. So you'll see here that is them saying that the PCP, the rule that everybody has to go through the online job application process, they found to be unfair, and did put people with a disability, particularly dyspraxia in this case, at a substantial disadvantage compared to those that didn't have that. And that is consistent with the Employment Tribunal's finding on this. So the tribunal found that it was unfair. The thing that changes here is that the employer applied to the EAT and appealed and said that it was flawed to say that they had actual knowledge of the disability, and that therefore the decision wasn't valid and it was an error of law. Whilst the EAT listened to that point, it perhaps didn't go quite the way that AECOM were hoping and expecting it to go on that point. And the EAT then said, okay, fine, maybe there wasn't actual knowledge, but there was constructive knowledge. Because Mr. Malon had emailed and said, I'm struggling with the online application form, I've got dyspraxia, please could I have a telephone conversation. So the EAT held and basically made clear in this, and it's a good thing to have in mind, that to trigger that duty for making reasonable adjustments, the employer must know that the individual has a disability, which on this occasion they did because he told them, and that might lead, or constructive knowledge that it may lead to them being placed at a particular or substantial disadvantage. So you'll see here that the Employment Appeal Tribunal then went on to talk about the expectation to make reasonable inquiries into that. So they said, okay, absolutely triggered the first point. You knew that he had a disability. What was also then triggered, in our opinion, is that you then knew that that was likely to place him at a particular or substantial disadvantage, and that you should have carried out reasonable inquiries on that. So talking to him about exactly what the difficulty was with him completing it online. Was there something else they could do with that? And essentially not just sitting on it when he then didn't respond to an email saying, we can give you a telephone call, and actually going on and being proactive and making positive steps to talk to him about the type of reasonable adjustments and reasonable steps to try and help somebody with a disability engage in the work or the application, whatever it might be. And that's really the key takeaway here, that it supports a proactive response from employers, and that's something that's worth having at the back of your mind, that actually the duty is on you guys to go and make those inquiries and say, what can we do to help? Particularly when somebody has come and said, I've got a disability, and perhaps not gone into too much detail on what that actually means for them and why that's causing them a problem. Not just accepting that on face value, and essentially having that chat and saying, what's the problem, what can we do, and exploring options. I've passed back to Nick.
Great, thanks, Laura. Our last case, and again, we're coming into land now. Interestingly, there's almost a bit of a trend between or following Laura's case, where I think increasingly employers are having to deal with discrimination cases that involve an element of neurodiversity. So dyspraxia in the last case, dyslexia this time around. And again, this just highlights some of the complexities on this. This case, Mr. Borg-Neal brought a claim against Lloyds Bank. And this one made the national press, as well as the sort of HR press, in a fairly significant way. And the background to this one is essentially that there was a race education training session, so diversity inclusion type training. And as part of a discussion around intent versus effect, Mr. Borg-Neal asked for some advice as part of the session on dealing with the use of words by individuals in a certain ethnic minority in the presence of people not in that minority, who might then take offence. And in doing so, he used the N-word in the presence of the trainer, who apparently then took offence at that. And I think the reports we've seen, it suggests that that trainer was then off work for a number of days with stress as a result. Following the internal disciplinary procedure that they then subjected Mr. Borg-Neal to, he was dismissed for gross misconduct for making that comment as part of the training session. He then brought claims for unfair dismissal and also disability discrimination on the basis that he had dyslexia. So that was essentially the issue that the tribunal had to grapple with. And I suppose, perhaps unsurprisingly, but it would be interesting to hear your views on it as part of the Q&A if we have time at the end. The tribunal found that his dismissal was unfair on the basis that the gross misconduct was too severe a sanction, and that it was also discriminatory on the basis that the individual had argued that his dyslexia significantly influenced how he expressed himself, and that in reality he may have struggled not to use the full word and come up with another way of phrasing the question that would have been more appropriate, perhaps in some people's eyes. Though I guess my personal view is, in that kind of training session, if the intention is good, then it should be a safe place for people to be able to discuss those kind of issues if you know, it's clear, which it appears to me, without actually having been there, that you know, it was intended in the right way. So again, a tricky one for employers. And I think, again, going back to the neurodiversity side of things, we're seeing an increase in workplace issues focused on that area. We're seeing a rise in diagnosis as well, and certainly more tribunal claims that are involving that kind of issue. So as Laura was saying, I think there's a real onus on employers to grapple with those issues well, perhaps to be considering medical advice if they don't feel qualified, because you're unlikely to be, to understand those issues to the extent that you might need to in order to get some of this HR employment stuff right, essentially. So I think that brings us towards the close. There's a couple of slides just following the Q&A session that I'll run you through very quickly. But does anybody have any questions on any of the many topics that we've covered that either you'd like to fire into the chat now or unmute and fire our way? Usually give it a few seconds for people to type away or find the unmute button, if that's helpful.
Heidi from Havintag.
Hi, Heidi.
How you doing? Thank you for that. Really interesting. I just wanted to ask about the disability pay reporting. Now, we do employ like 20% of our employees are disabled. So would you think it would be a good thing that if we could, actually we've got very equality of pay and fairness. Would that be a thing that we should maybe be encouraged to report back on, do you think? Just in terms of, I suppose, attraction and things like that. I'd just be interested in your opinion on that, whether that would be something that we should maybe be pursuing.
James, you want to go first?
Yeah, I can do. I don't see why not, Heidi. I mean, as you say, it's a potential selling point. I mean, there wasn't much substance behind the proposals that I'd read, just the sort of premise. So how you'd actually be required to do it, if you ever are required to do it, who knows? But if you have data that's actually useful and potentially attractive, I don't see what you've got to lose. Given that you already have to do potentially gender pay reporting, why not do more to create a more balanced picture? Because in some ways that's part of the drive for other characteristics. Because whilst gender pay reporting is important, why not others? People are interested, and it shows your equal opportunities if you can actually demonstrate that. My concern is just as a statistician that if you've got 4 people and 2 of them do this, 1 of them does that, it doesn't show anything at all. But if you have the numbers there, it can do. So why not?
Yeah.
Okay.
And it
Brilliant.
might well be helpful for employer brand by the sounds of things. So
Yeah, no,
yeah,
could be an idea. Thanks, Nick.
sounds good.
Thanks, James.
Anybody else?
Nick,
Hi, Nick.
I'll go. It's Andrew Beaumont.
Hi, Andrew.
Hi. So on the last case, on the disability one with dyspraxia, I'm really intrigued as to whether the individual who was dismissed showed any remorse whatsoever.
As in the Lloyds Bank case with
Yes,
the dyslexia
as in,
one.
Yeah, as in the individual who used language that shouldn't have. Whether there was any remorse on their side from, I can understand why my colleague was offended, or all of that kind of stuff. Because that for me would be a fundamental test in a hearing about whether the remorse was there. Sure.
Yeah, I think you're right. I think in a lot of cases, someone facing any kind of disciplinary, showing remorse and taking the view that, I'm sorry that this happened, if that's the case, it is certainly a factor that the employer can take into account. I guess the eventual end result of this case was that he was unfairly dismissed and discriminated against. So it may well be that he that he didn't, go down that track. And that probably would have been fine, had that been the case.
Just to jump in, Nick, I've cheated and asked John, who's our trainee, Andrew, sitting in the room with me, who's done a lot of the hard work to put this together behind the scenes, and he's told me that the claimant in the case did apologise straight away and repeatedly throughout the disciplinary process. Yeah. So that will no doubt have gone into the sort of melting pot of reasonableness when the tribunal was applying the broad test, certainly on the unfair dismissal claim.
Yeah.
Thank you.
So, well, thanks to John.
Anybody else?
Hi, Nick. It's Tracy from Loomis UK.
Hi, Tracy.
Hello. So I know that the ethnicity pay gap has been coming for quite a long time, and it's been mooted that it was coming for quite a long time. My current company, we've moved to a new HR system, and one of the things we're looking at is our data. And I do know that we do have masses of gaps in our ethnicity data. So it's basically, we want to ask people to go into their records and put their ethnicity on, but there is this real feel that it's Big Brother and etc. So it's finding, I suppose, the the way in to encourage those to do that without them feeling that, you know, we are poking into their private lives, as it were, because we need this data in order to produce the pay gap data.
Yeah. James, you want that one in your section?
Yes, this is my section. I think it highlights it's a very good question, because it highlights a potential flaw that the legislators are going to have to cover, because I guess that certainly with the current reporting requirements, you don't have that problem, because even if you're just making assumptions, it's going to be right in the vast majority of cases. Whereas on ethnicity, as you say, if people don't declare it, then you don't know. If it's not mandatory, you could be required to report it and say, well, only 10% of our workforce is providing the data. It makes it meaningless. So I agree. It's a very good point, and it'd be interesting to see how that's covered, whether it'll become mandatory that employers will have to declare that.
Because I mean, obviously, because we've got an integrated payroll and HR system, which is great, because for tax purposes you have to have gender in there, so we have got that gender data. But I suppose for ethnicity, you can put unknown. We have to have that option. So we do have people that will go on and proactively put what religion and race, etc. they are. But you do have some people who put not declared, unknown, etc., which leaves us in a very bad position that there is this block of people we don't know. So how do you report on the unknown? Well, so it'll be interesting to see how that comes out in the law.
Yeah, I mean, it makes me think that they're going to have to, and they did this with those of you that remember, it was a long time ago now, the gender pay reporting, that was sort of expressly a thing that you'd have to do, but the actual implementation date after they put the law in was a long day down the line. And I'm guessing they'd have to do something similar here, just to allow you the lead time to collect all the data and then have enough data to analyze. Because as you say, at the moment, it would be a meaningless exercise, because it wouldn't show anything. It would just show that you didn't have the information to report, or what you could report would be useless.
Yeah, I think we're going to start chipping away at it anyway, because for demographics, it's really interesting to understand your workforce, as it were. So it is something that's good.
You could encourage, but as you say, at the moment, if they don't provide it, that's that's their choice.
I was going to say, I think it's at the moment it's probably more of a PR exercise, isn't it? In saying, look, diversity is really important to us. This is something that we'd like to be able to report on and understand better, so that we can support you better. You know, we'd love that data, please. But you're right, it'll be interesting to see where it goes.
And Alison has made the same point in the chat that the data's not there for them either. I imagine you're not alone.
Yeah, good to know. But Thank you.
Great. Thanks, Tracy. Anybody else? Maybe take one more. We're approaching the scheduled finish time, if there is one more question. Thanks to everybody so far for those. No. Right. Okay. Well, in that case, just a couple of slides to finish. For those that missed it at the beginning, because you may have not logged in, there are a few things we just wanted to highlight. One was a free employment contract review that we're doing. Gives you a report with any issues around legal compliance in your employment contracts. There are a few out there that we're still seeing that are missing some fundamental sort of bits that need to be in there. We do our webinars like this pretty much every month, but we also do bespoke training, both online and in person, for our clients. So if that's of interest on any of the topics that we've talked about, diversity and inclusion being one of the really important ones that we're doing a lot of at the minute, we'd be happy to talk to you about that. We have the East Midlands HR Network, which is in the chat. Yvette might pop a link in there again, as well as the HRD Talks podcast. The most recent episode was with Pat Woodfield, who's the executive group director at the YMCA group. And hopefully you'll find that useful. You can see that on our website at that website address there, or in fact on your favorite podcast provider. And again, we trailed this and we may be regretting it, but it's a Christmas special on the 13th of December. And the plan is to try and make it Christmassy, fun, educational, interactive. So we'll let you guys be the judge of that. If you can join us, or your teams can join us. We're hoping to have a bit of fun and cover some employment law issues as well. So it'd be great to see you there. Thanks, James and Laura, for your presenting. Thanks everybody for joining us, Iveta for making it all work in the background, and we look forward to seeing everybody next time. Thanks.